Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. The Supreme Court 7-judge bench today continued hearing a reference of the 1998 PV Narasimha Rao judgment, which held that MPs and MLAs could claim immunity from prosecution for receiving bribes in relation to any parliamentary vote or speech. Senior advocate Gopal Shankaranarayan, who is arguing in favor of reconsideration of the PV Narasimha Rao judgment, continued with his submissions today. He said that strict interpretation had to be given to laws dealing with corruption which affect public will. In case of a criminal act, it can be immune only if it is directly related and proximate to the speech made or vote cast. He cited the example of a recent speech made in the parliament by MP Ramesh Bidori, who hurled expletives. The senior advocate said that parliament ensured that those words were struck off, but in his view, it was a crime. Many hues of hate speech and provisions of IPC would be attracted, but whether we liked it or not, it's something he said during a debate. However reprehensible his conduct may have been, he did have privilege when he said so. Shankaranarayan further proposed a test to determine scope of immunity. He said, when an act is essential for undertaking legislative functions, the legislator does have the protection. And if there's any interference with parliamentary process, then immunity cannot be claimed. Next, senior advocate Vijay Hansaria submitted that expulsion from legislature was not a substitute for criminal proceedings. He also presented details of cases pending against legislatures and said that the court should take into account the figures when interpreting the provisions of the Constitution. The bench today also heard Attorney General R. Venkataramani, who said that protection under Articles 105 and 194 of the Constitution confined to work, business or functions of Parliament or state legislature. Election to Rajya Sabha was an independent process governed by special set of rules and not a business of the Parliament, and as such would fall outside the scope of these articles. Solicitor General Tushar Mehta also argued and said that self-regulation was an essential ingredient of the separation of powers between all three organs. Parliamentary privilege was essentially against the executive, but the law that has developed confers right and power of exclusive self-regulation on all three organs. Independence of self-regulatory power of Parliament is as sacrosanct as the independence of judiciary or executive. In the end, senior advocate Raju Ramchandran made his rejoinder arguments, post which the Constitution bench reserved judgment in the matter. To read the arguments in detail, you can visit our website at livelaw.in. The Supreme Court bench comprising Justice Sanjeev Khanna and Justice S.V.N. Bhatti today heard Aam Aadmi Party leader Manish Sisodia's bail applications in relation to CBI and ED cases over alleged Delhi liquor policy scam. Yesterday, as you know, the bench had asked why the political party, which was alleged to be a beneficiary, was not made an accused in the case under the Prevention of Money Laundering Act. Today, senior advocate Dr. Abhishek Manu Singhvi, appearing for Sisodia, took objection to the press reports about the court's query, saying that certain media houses had reported that the Enforcement Directorate was planning to add Aam Aadmi Party as an accused in the case. But the court clarified that the question was not meant to implicate anyone and that the bench was not influenced by the media reports. Further, Additional Solicitor General S.V. Raju argued on behalf of ED. He presented various WhatsApp chats and emails exchanged between excise officers. He said that Vijay Nair conveyed to the MNCs that they should give funds to Aam Aadmi Party to get a favourable policy, which was a direct demand of bribe, and that it was well corroborated by a contemporaneous WhatsApp chat. He also said that Indospirit, a leading importer and distributor of alcohol beverages, was not getting the wholesale. There were some complaints against the partners of Indospirit, so they were not eligible to get the wholesale. and that Manish Sisodia had intervened to have the said complaints removed. But Justice Khanna asked to show how the money was going to Sisodia. In case it was a company with whom he was involved, then it would be a case of vicarious liability. But money laundering was entirely a different offence. PMLA would be triggered after proceeds of crime were given or paid. The matter will now be taken up on next Thursday, that is 12th October. Stay tuned with us. In another update, the Supreme Court has asked the consortium of national law universities if the NLUs could accommodate students for the academic year 2023-24 who had applied for admission in the National Law University Tripura last year. NLU Tripura had started its admission process for the academic year 2022-23 last year, but could not commence its operations due to lack of facilities and teachers. And all the 90 students who had taken admission were given a refund of the fees. A writ petition has been filed before the Supreme Court by 19 students who challenged NLU Tripura's decision to cancel the admissions. The matter was heard by a division bench comprising Justices Sanjay Kishan Kaul and Sudhanshu Dholia. The court described this state of affairs as an unsatisfactory situation. The court was informed that for the academic year 2023-24, with the availability of facilities, NLU Tripura carried out a fresh admission process. However, the process was not conducted under CLAT, as NLU Tripura will be covered under CLAT only from the next academic year. The court was further informed that there were candidates who got admission in other NLUs, but due to proximity did not want to go to the other institutes. With respect to the candidates who have been left out and are desirous of seeking admission, the court asked Senior Advocate Maninder Singh, appearing on behalf of the consortium, whether those students could be accommodated for admission in this academic year, that is 2023-24, provided they show that they had got admission. The senior advocate sought some time for instructions, and accordingly, the court has listed the matter on 16th October. In the next update from Supreme Court, it today directed for a medical examination of a woman seeking termination of 24-week pregnancy of her third child, citing health conditions. A bench of Justice Hima Kohli and Justice B.V. Nagratna was considering a plea for medical termination of pregnancy of a married woman who is beyond 24 weeks pregnant. She informed the court that she was a mother of 2 children and was suffering from lactational amenorrhea and postpartum depression, and so was not in a position to raise another child. The bench initially expressed its disinclination to entertain the plea, noting that the conception was voluntary. When the petitioner's counsel explained that she came to know of her pregnancy belatedly, the court questioned as to why she did not realize that she might be pregnant after 5 months of missing her period. The counsel further informed the court that she was under psychiatric treatment, taking medication, and apprehended that the child born might not be normal. Though the bench orally remarked that if such a plea was allowed, it would open the doors to parents who get cold feet at the last minute, but it did issue notice in the plea directing a medical board to be constituted by AIIMS to assess the medical condition of the petitioner. The petitioner has been asked to be present before the medical board tomorrow, and the matter has been posted for further consideration on 9th October. In an important update, the Calcutta High Court has held that deactivating Aadhaar card might in reality have the consequence of terminating citizenship, because such deactivation has severe consequences on a person's right to live a dignified life as enshrined under Article 21 and to pursue vocations under Article 19. The case relates to a writ petition filed by a woman and her family members whose Aadhaar cards were suspended by the Ministry of Home Affairs on alleged grounds of them being Bangladeshi nationals. Counsel for the petitioner argued that the petitioner's Aadhaar cards had been deactivated during the pendency of the writ petition, which led to their voter ID and PAN cards being consequently suspended. that no inquiry had been conducted as contemplated under the Aadhaar regulations, and that the petitioners had not been informed of any grounds for the suspension of their Aadhaar card. On the other hand, ASG for the Union government submitted that the ministry had received reports from a central security agency which indicated that petitioners had fraudulently obtained their Indian documents and it was entitled to take appropriate action. After hearing the parties, court noted that the only grounds under which citizenship of individuals could be challenged were enlisted under the Citizenship Act. While the authorities had not terminated the petitioners' Indian citizenship, the revocation of their Aadhaar card had severe consequences on their quality of life, being a de facto termination of citizenship. Court held that in the absence of a formal adjudication or inquiry, the respondent authorities could not have taken away the basic rights of the petitioner and her family as Indian citizens. Accordingly, court stayed the suspension of Aadhaar cards but allowed the respondent authorities to proceed on the basis of the impugned memoranda while complying with all statutory procedures. The matter has been listed for further hearing on 5th December. The Allahabad High Court has observed that a Hindu marriage cannot be solemnized unless the Saptapadi ceremony, that is, taking of 7 steps by the bridegroom and the bride jointly before the sacred fire and other rituals have been performed. Justice Sanjay Kumar Singh was considering a petition filed by Smriti Singh challenging a complaint filed against her by her husband for bigamy. According to the complaint, they got married in June 2017, but in September 2017, the wife married another person, and now she was living with her second husband without getting a divorce from the complainant. A magistrate court, after recording the statement of the complainant and his witnesses, summoned the applicants as well as other co-accused persons. Challenging the same, the applicant, that is the wife, and others moved the High Court. She argued that the complaint filed by her husband was a counterblast case, as she had already lodged an FIR against him and his family members. She also denied solemnization of marriage with any other person. Importantly, it was argued that in the complaint and statements of the complainant as well as witnesses, there was no assertion regarding the solemnization of marriage and ceremony of Saptapadi. Noting that the parties before the Supreme Court were Hindus and Saptapadi ceremony under the Hindu law was one of the essential ingredients to constitute a valid marriage, the court said that evidence regarding the performance of Saptapadi ceremony in the alleged second marriage was lacking. Consequently, the court observed that no offence of bigamy was made and terminated the criminal proceedings against the wife. In another update, the Supreme Court has modified a condition imposed by a family court requiring the father to meet the child in the premises of the court. This was in a matrimonial dispute related to a child's custody where the family court had allowed the father to have visitation rights of the child on Sundays between 11 a.m. and 4 p.m. at court premises. Since the Kerala High Court did not interfere with this condition, the father approached the Supreme Court. He contended that the condition confining the child to the empty precincts of the family court on a Sunday in the presence of court officers and a police officer was not conducive for the welfare of the child. He argued that such a condition would not make the visitation meaningful and joyous. The Supreme Court bench of Justices A.S. Bopanna and Manoj Mishra, observing that the environment also matters, modified the condition allowing the father to meet the child at a mall every Sunday for 3 hours. The court allowed the visitation rights to be exercised at RP Mall, Kollam, and added that the father will have to hand over his son to the mother after 2 p.m. at the entrance of the mall. And lastly, in a case of matrimonial dispute, renowned cricketer Shikhar Dhawan was granted divorce from his estranged wife Aisha Diwan on grounds of mental cruelty by a family court in Delhi. The couple got married in 2012 and have a 10-year-old son together. The respondent has 2 daughters from a previous marriage and she was living in Australia. The parties were living separately since August of 2020. The petitioner, Mr. Dhawan, claimed that the respondent, that is his wife, had given him assurances that they would live together after coming back from Australia. The court accepted the petitioner's allegations that his wife backtraced from her promises, made him suffer a long-distance marriage, kept the child away from the father, compelled the petitioner to make her co-owner of 3 properties in Australia, and committed to stay back with her former husband in Australia. It was held that their matrimonial relationship was dead long back. The court thus granted divorce to the cricketer on the ground of mental cruelty. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.